Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Marlabs Innovations Private Limited vs DCIT, pronounced by Bangalore Tribunal on the 8th of June 2026. Marlabs Innovations Private Limited is engaged in custom software application development and IT-enabled services. For assessment year 2022 to 23, the Assessee filed a return declaring total income of 35 crore, 94 lakh, 83,750. The case was selected for scrutiny. The transfer pricing officer proposed an adjustment of 23 crore, 16 lakh, 49,912 under Section 92CA(3) on the 10th of January 2025. Conforming to this, the assessing officer issued a draft assessment order on the 19th of March 2025 proposing an income of 59 crore, 29 lakh, 35,662. The assessee objected before the DRP 2, Bangalore. The DRP partially allowed the objections via directions on the 3rd of December 2025. However, the AO passed the final assessment order on the 18th of December 2025, erroneously treating the DRP directions as a rejection of all objections, assessing income at 59 crore, 29 lakh, 35,662. The TPO, in a separate order dated the 24th of December 2025, gave effect to the DRP directions and reduced the transfer pricing adjustment from 23 crore, 16 lakh, 49,912 to 6 crore, 71 lakh, 47,000, granting a relief of 16 crore, 45 lakh, 2,912. The assessee contended before the ITAT that the final assessment order was not in conformity with the DRP directions. It relied on the Karnataka High Court decisions in PCIT vs Flextronics Technologies, India, Private, Limited 2023, 459 ITR 493 in PCIT vs Messrs VMware Software India Private Limited, ITA number 221 of 2023. The revenue cited Hitachi Astemo Haryana Private Limited vs DCIT, Delhi ITAT, arguing that the matter could be remanded instead of quashing the assessment order. The ITAT first examined the AO's finding that the DRP had rejected all objections. A perusal of the TPO's effect order dated the 24th of December 2025 revealed that the DRP had indeed granted partial relief, particularly reducing the software development segment adjustment to nil from 15 crore, 88 lakh, 10,000. Section 144C, 13, explicitly states that the AO shall pass the final assessment order in conformity with the directions issued by the DRP. The ITAT held that this is a mandatory requirement, not a directory one. The AO's non-compliance constituted a clear violation of the statutory provision. The revenue's reliance on the Delhi ITAT decision in Hitachi Astemo was distinguished. The ITAT noted that the jurisdictional High Court for the Bangalore bench is the Karnataka High Court. The decisions in Flextronics and VMware are directly binding, and the Supreme Court dismissed the SLP in VMware, affirming the High Court's view. Given the violation, the ITAT quashed the final assessment order in its entirety. It observed that once the foundational order is invalid, the other grounds raised by the assessee become academic and were kept open. The ITAT allowed the appeal of Marlabs Innovations Private Limited, quashing the final assessment order for assessment year 2022 to 23. The ruling reinforces that the AO must meticulously implement DRP directions. Any deviation invalidates the assessment. The other issues were kept open for re-argument if a fresh assessment is initiated. Question: what is the key legal principle established in this case? Answer: The core principle is that under Section 144(c)(13) of the Income Tax Act, a final assessment order must be in strict conformity with the directions of the Dispute Resolution Panel, DRP. Failure to do so renders the order invalid and liable to be quashed. Question: why did the ITAT quash the order instead of remanding it? Answer: the ITAT followed the binding Karnataka High Court decisions in Flextronics and VMware, which held that non-compliance with DRP directions is a jurisdictional error that cannot be cured by remand. Quashing is the appropriate remedy. Question: does this ruling apply to all taxpayers or only those in Karnataka? Answer: the ruling is directly binding on ITAT benches under the jurisdiction of the Karnataka High Court. However, other benches may be persuaded by the reasoning, especially given the Supreme Court's dismissal of the SLP in VMware, adding strong persuasive value. Question: what should a taxpayer do if the AO passes a final assessment order ignoring DRP directions? Answer: the taxpayer must promptly appeal to the ITAT, citing Section 144(c)(13) and the Jurisdictional High Court's precedent. The order will likely be quashed, and the AO will be directed to pass a fresh order in conformity with the DRP directions. Question: were the other grounds of the assessee decided in this appeal? Answer: no. The ITAT kept the other grounds, such as the ITES segment adjustment, open, meaning they remain unresolved. If the revenue takes any further action, the assessee can re-agitate those issues. Question: what is the takeaway for the revenue? Answer: the case reinforces that the AO must carefully implement DRP directions. Any misreading or oversight, even if the AO believes the DRP rejected all objections, can lead to the entire assessment being quashed, resulting in wasted time and resources. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.